This was an employment discrimination case that we brought under the Americans with Disabilities Act. Ms. Williams has disabilities that arose out of her time serving in the U.S. military. At the time of our case, she had been working in the clerical department, in records and warrants. Normally, she worked the day shift. However, the sheriff's office made a change that had her moving to the night shift. She was now required to walk by herself at night through a long parking lot in order to get to her car. Now, she did experience some symptoms arising from her PTSD as a result of this. She talked with her doctors at the Department of Veterans Affairs about it, and she received a letter to her supervisors explaining what she was experiencing. Her supervisors were very accommodating. They arranged for a gentleman in her division to walk her to her vehicle at night, and that was really all she wanted and all she needed. Even though she continued to perform her job well, when former Sheriff Victor Hill received notice that she had the disability and had requested accommodations, he immediately sent an email, do a fit for duty status and release her from employment. The Sheriff's Office defense was that this did not actually mean to release her from employment. The jury did not buy that argument. The defendant also argued that Ms. Williams wasn't fired for her disability, but because she came to work with bright red hair one day. Now, the hair issue emerged the very day after the test results came back from Ms. Williams' fitness for duty, showing that she would likely need some accommodation. We presented the jury with a photo taken a few days earlier that showed her with an appropriate conservative sort of color in her hair. And we also presented the jury with evidence that under the Sheriff's Office's own policies, if someone comes to work not according to dress code, that they're to be given a warning, sent home, and then offered a chance to come back. The jury found Ms. Williams had been terminated based on her disability and terminated in retaliation for requesting accommodations for her disability. They awarded her damages amounting to 2 years of back pay plus $138,000 in damages for emotional distress and the like. In Georgia, there are very few state employment laws, and so we rely on federal laws like the Americans with Disabilities Act. For that reason, few cases go to jury trial. So we're very proud to be able to take a case like this to a jury trial, and it feels really good to win.